conditionally discharged restricted patient under the Mental Health Act 1983. In short summary, and I will set out the detailed factual chronology and relevant law shortly, the appellant is subject to a restricted hospital order imposed by the Crown Court. He was conditionally discharged and made a valid application to the First-tier Tribunal in that capacity. He was then recalled to detention in hospital by warrant of the Secretary of State, who referred his case to the tribunal and had a duty to make that reference within 1 month of the patient's return to hospital. The tribunal decided that it no longer had jurisdiction to deal with the application made while the patient was conditionally discharged by reason of the provisions of Section 75 of the Mental Health Act 1983, although the reference could be dealt with. The Upper Tribunal upheld that decision of the First-tier Tribunal. This is therefore a second appeal. The respondent was a party to the proceedings from the outset, but his first substantive response to the appeal was received in August of this year when he filed a skeleton argument. Since then, the parties' positions have been refined and clarified with repeated exchanges of written arguments. The most recent was filed by the respondent 13 days ago. The issue...
Well, we have skeleton, respondent skeleton, appellant's supplementary note, respondent's addendum note.
Yes.
Good.
My Lords, the issue is one of statutory interpretation.
Yes.
Whether, where a restricted patient who has been conditionally discharged makes a valid application to the First-tier Tribunal, the Tribunal's jurisdiction to adjudicate that application survives the change to the patient's status under the Act that results from him being recalled to detention in hospital by warrant of the respondent.
Yes.
The appellant says it does, the respondent says it doesn't. I should add that on the 2nd of last month, by consent, the Southern Health NHS Foundation Trust, which was technically a respondent and was a party in the first tier, was removed as a respondent, and the order can be found at page 106 of the core bundle. The Secretary of State is therefore the only respondent. In relation to the facts and relevant statutory provisions, the appellant is diagnosed as suffering from paranoid schizophrenia. On the 19th of October 2016, he pleaded guilty to attempted murder. The reference I give for that is Upper Tribunal Judge Jacobs' decision at paragraph 2 on page 82 of the core bundle.
There is a helpful chronology described as appellant's chronology, tab 4, page 28.
Yeah.
I assume none of it's in dispute.
It isn't.
Good.
As I understand it.
The so the 2016 event you just mentioned is there.
Yeah.
There was one date I was interested in, perhaps you can tell us. 1st of March 2024, Secretary of State decided to recall AC to detention. Then 10th of April tribunal decided it lacked jurisdiction? Do you know when the reference was made?
Yeah, that's a good question. My search of the papers has only told me that it was made very quickly.
Yes, within the 1 month. Well, if somebody could find that at some stage, it's not critical.
Was it 2 days?
It was the 5th of March, according to the paperwork in the Commission bundle, but that's not in here, I'm afraid.
That's fine. Thank you.
So, to go through the relevant statutory provisions in a chronological fashion, if I may. On the 16th of November 2016, the appellant was made subject to a hospital order with restrictions. That order and those restrictions were made under sections 37 and 41 of the Mental Health Act. Section 37 is at page 16 of the authorities bundle. I don't know if your lordships need to go to it because...
Well, 37 and 41 are fairly familiar to anybody who's sat in the Crown Court.
Yeah. Well, if we can go to it briefly.
Yes.
At page 16 of the authorities bundle, you see section 37, powers of court to order hospital admission, guardianship. And I would refer in particular to subsection 1 for the court's discretion to order admission to hospital, and subsection 2 for the evidential preconditions to the exercise of that power. Section 40 of the Mental Health Act 1983 provides for the effect of a hospital order. That's at page 26 of the authorities bundle. To summarise, with 3 exceptions, a patient who is made subject to a hospital order but not a restriction order is treated the same by the Act as a patient admitted under Part 2 of the Act, where what are known as the civil sections are, like Section 2 and Section 3. But most relevant to this case is subsection 4 of section 40, which is a complex section that refers to Schedule 1, Part 1 of the Act, which we needn't go to. But the effect of subsection 4 of section 40 is important, because it modifies the Part 2 regime by Part 1 of Schedule 1. And the modification relevant to this case is that an unrestricted hospital order patient is not allowed to apply to the First-tier Tribunal in the first 6 months of his detention subsequent to the hospital order. The effect is that the first right to apply arises after the detention is renewed for the first time under section 20, subsection 1. So the judge imposes...
Just say that again. This isn't in your skeleton, is it?
No, it isn't. The effect of section 40, subsection 4 is to prohibit an unrestricted hospital order patient from making an application to the First-tier Tribunal in the first 6 months of his detention. So the judge imposes the order. The patient has to wait 6 months before he obtains a right from the Act to go to the First-tier Tribunal to argue that he should be discharged.
Yes.
Section 41 of the Act, at page 28 of the Authorities Bundle, provides the sentencing judge with a discretion to restrict the patient's discharge from the hospital order where it is necessary for the protection of the public from serious harm. So to do. The special restrictions which apply to restricted patients are set out in section 41, subsection 3, on page 28 of the Authorities Bundle. Paragraph A disapplies the provisions of Part 2 of the Act relating to the duration, renewal and expiration of authority for the detention of patients. The effect is that a restricted hospital order patient continues to be liable to be detained by virtue of the restricted hospital order until he is duly discharged under Part 2 or sections 42, 73, 74 or 75. The effect essentially is this: a restriction order attached to a hospital order means that the patient remains a restricted patient liable to be detained at all times until he is absolutely discharged. And another way of saying absolute discharge is the restriction order ceases to have effect. And that discharge can come either from a tribunal or the Secretary of State. So there is no periodic review by the responsible clinician, the doctor with statutory authority and duty to treat the patient. There is no periodic review by that doctor of the grounds for authority to detain. The patient cannot be discharged, transferred or granted leave of absence without the consent of the Secretary of State, unless it's by the tribunal in relation to discharge. There can be no discharge on a community treatment order, which is the Part 2 equivalent of a conditional discharge, in essence. And the authority to detain lasts as long as the restriction order is in force.
Whereas a Section 37 patient can be discharged by the
Yes.
hospital. Yes.
As can Section 3 and Section 2 and Part 2 patients generally. The point is, my Lord, that not only can they be discharged by the responsible clinician without the consent of the Secretary of State, they can also be discharged by their nearest relative. The restricted patient doesn't have a statutory nearest relative.
Doesn't?
No, doesn't have a statutory nearest relative because then there is no power to make decisions about a restricted patient's case in any Upper Tribunal and the Secretary of State.
Yeah.
And there's no renewal. We don't need to go into this, but in normal hospital order cases and in the Part 2 powers, they all have a limited duration, at the end of which authority for detention expires unless it is renewed. But that doesn't apply to restriction order patients. Section 70 at page 85 of the Authorities Bundle is at the heart of this appeal. Section 70 does the same thing for restricted hospital order patients as subsection 4 of section 40 does for unrestricted patients. In subsection A, section 70 provides that a restricted patient does not have the right to apply to the First-tier Tribunal for his discharge in the first 6 months of the restricted hospital order. So in the case of both restricted and unrestricted hospital orders, where, well, both can only be imposed by a judge, and the Act's policy where detention in hospital is imposed by a judge is for the tribunal not to have jurisdiction the first 6 months, because there is no need for judicial supervision of a hospital order that has recently been created by a judge. It is a judicial detention rather than an administrative detention. On the 22nd of October 2021, the appellant was conditionally discharged on detention. By the tribunal. Section 73 of the Mental Health Act, which is at page 92, governs the tribunal's adjudicative jurisdiction in relation to restricted patients. The adjudicative jurisdiction can be seen in the first line of subsection 1 of section 73. And it reads, as you can see, where an application to the appropriate tribunal is made by a restricted patient who is subject to a restriction order, or where the case of such a patient is referred to the appropriate tribunal. And then it goes on to describe the choices that the tribunal has and the duties that it has. But the wording that I would wish to emphasize is the phrase "is made by a restricted patient who is subject to a restriction order." It doesn't refer to a restricted patient who is subject to a restriction order and is detained in hospital. Section 73.
Might be worth noticing on section 73 that the perhaps this is the point I thought you moved on.
I'm sorry.
No, I thought you were moving on. So you carry on.
No. I'm still on section 73, my lord. Section 73 requires the First-tier Tribunal to first decide whether the criteria in section 72(1)(b) are satisfied. So it imports 3 of the criteria in section 72(1)(b) and requires the tribunal to decide whether it is satisfied that all of those criteria are met in the case of the restricted patient at the moment in time that it is hearing the case. Section 72 is at page 88 and is worth looking at. So, section 72 1b is the relevant sub-paragraph of subsection 1 that is imported by section 73, and it requires the tribunal to direct the discharge of a patient liable to be detained otherwise than under section 2 above if it is not satisfied. And then I would wish to emphasize the first 4 words of subparagraph 1, little Roman numeral 1, that he is then suffering from mental disorder or mental disorder of a nature or degree which makes it appropriate for him to be liable to be detained in a hospital for medical treatment. Or, two,
shall direct the discharge if it is not satisfied that he is then suffering. Yes.
2 is that the criterion is that it is necessary for the health. Actually, the Thomson Reuters copy contains a misprint. It should be or, not of. That it is necessary for the health or safety of the patient or for the protection of other persons that he should receive such treatment, the treatment referred to in subparagraph 1. And then the third criterion is 2A, and that is that appropriate medical treatment is available for him. It is those 3 that are imported into section 73 by section 73(1). The point of interest there is that these are disjunctive criteria, indicated by the word or. So the tribunal must be satisfied of all 3 for the duty to discharge not to arise. So, for example, if it is satisfied that the patient is suffering from a mental disorder of a nature or degree which makes it appropriate for him to be liable to be detained in hospital for medical treatment, but it is not satisfied that it is necessary for the health or safety of the patient or for the protection of other persons that he should receive such treatment, then the duty to direct discharge arises. Returning to section 73, subsections 1 and 2 on page 92 set out a choice for the tribunal in the event that it finds that one of the criteria in section 72(1)(b that we have just looked at is not satisfied on the evidence. It is, if I can put it in this way, a duty to make a choice between one or the other. There is a duty to discharge, but section 73, subsections 1 and 2 provide the tribunal with a discretion as to whether or not that discharge should be absolute, which brings the restriction order to an end, or conditional. And
that turns on 73(1)(b, does it?
It turns on 73(1).
It's an absolute discharge if satisfied of A and B.
Yeah, that's section 73(1) before you even get to A. So in 1, the tribunal must direct the absolute discharge of the patient if one of the section 72(1)(b) criteria are not satisfied, and B, and this is the critical thing for the choice, that it is satisfied that it is not appropriate for the patient to remain liable to be recalled to hospital.
If any of the three in 72(1)(b) is not satisfied, then there's going to be a discharge.
Yes.
The question of whether or not it's absolute or conditional turns upon whether the tribunal is satisfied that it's not appropriate for the patient to remain liable for recall.
Precisely. If the tribunal is not satisfied that it is not appropriate for the patient to remain liable to be recalled, then there's a conditional discharge. Conditional discharge does not, like absolute discharge, cause the restriction order to cease to have effect. The patient remains liable to be detained, liable to be recalled to detention in hospital, and also, if any conditions are imposed, either by the tribunal or the Secretary of State, under the conditional discharge, the patient is obliged to comply with them. The process by which tribunals direct conditional discharges has the potential to be extremely complex and often very lengthy. It's a whole area of jurisprudence in itself about what they can do and how they should do it. And I don't intend to take your lordships through all of that. But it is worth noting subsection 7 of section 73, which gives an indication of what the tribunal may do under section 73. In short summary, subsection 7 allows the tribunal to defer a direction for the conditional discharge of a patient until such arrangements as appear to the tribunal to be necessary for that purpose have been made to its satisfaction. I won't go through the rest because it opens a can of worms, which has been the subject of a lot of litigation in the higher courts. But in short summary, what subsection 7 allows the tribunal to do is say, for example, we think that if this person was provided with suitable aftercare outside hospital, for example, supervision in a community by a forensic community mental health team, living in a specialist mental health accommodation, these sorts of things that are there to protect the patient's mental health, but crucially also there to protect the public from the consequences of a relapse. The tribunal can say, none of those things are available on the evidence today, but we think that were they to be available, the patient would be entitled to be discharged because one of the section 72(1)(b) criteria would not be satisfied, one or more of those criteria. Hence the deferral, which invariably is accompanied by directions for the production of evidence about whether this aftercare is available. there has been great controversy over the years about the legal and procedural consequences of a deferral, and it is now treated as a provisional decision in most cases, so that the tribunal, when the evidence comes in or doesn't come in, can reconsider its decision, and the patient isn't left in limbo. But none of that is relevant to this case. It's just, well, not directly relevant, but it does indicate how complicated the process can get, and sometimes it takes years. The Secretary of State has his own powers to direct conditional discharge and absolute discharge of restricted patients in section 42, subsection 2, which is at page 31 of the authorities manual. So, under subsection 1, the Secretary of State may, if he is satisfied that in the case of any patient a restriction order is no longer required, direct that the patient shall cease to be subject to the special restrictions set out in 41. That isn't about directing an end to the hospital order. It's just removing the restrictions from the hospital order. Subsection 2 allows the Secretary of State to direct conditional discharge in the same way as the tribunal, and also to direct absolute discharge, and that does bring the whole thing to an end, the hospital order and the restriction order. And section 3, subsection 3, we shall come to in a moment, because that's about recall. And it's just 2 steps down the chronology.
Yes.
On the 13th of October 2023, the appellant applied to the tribunal while he was under the conditional discharge. And this is where section 75 comes into the equation for the first time. Your Lordships will have seen that section 75 is at the heart of the controversy.
Yes.
So the subsection relevant to what the appellant did on the 13th of October 2023 is subsection 2, where a restricted patient has been conditionally discharged as aforesaid, that refers to subsection 1, but has not been recalled to hospital, he may apply to the appropriate tribunal. And
in certain periods.
Yeah. So subparagraph A provides that the first time that he may apply after a conditional discharge is after the expiry of the first 12 months of the conditional discharge. So he has to wait a year. And then every subsequent period of 2 years.
And in fact, he waited almost, but not quite, 2 years. Yes.
The rationale behind it is that he isn't deprived of his liberty on a conditional discharge.
I'm sorry,
He is not deprived of his liberty
No.
on a conditional discharge.
Sure.
So the requirements are less stringent
Yes.
than were he to be.
And in that context, the period, we were thinking about what apply means, which is perhaps at the heart of this appeal. In the context of the periods, what does it mean? When is the application at the point when the application is first made, or when it's determined?
The former. The appellant would say.
So in determining whether he falls within the periods, you look at the date on which he files the application.
Yes, and the rationale for, well, the reason for that, the reason the appellant says that is because he could apply on the last day of a period. And it would be absurd were he to be allowed to apply on the last day and then for what he did on that last day of the period to evaporate as an effective application.
And jumping ahead, without, I hope, interrupting your flow, you say, do you, that the word apply must mean the same throughout the subsection. So if that's what it means when you're thinking about periods, it's also what it means when thinking about has not been recalled to hospital.
My Lord, yes. I would put it even more simply. The word apply means what it says.
Yeah, well, yeah.
Well, it doesn't quite cover it because, in one sense, you apply when you make your initial application, you put in your papers, but you could also be said to apply when you turn up at the hearing and ask to be absolutely discharged. But you say in the context of this legislation, it means the former.
Yes, it must do, because I don't see how it could mean the latter when the only reason that there's a hearing for you to turn up to apply is because you have made an application to institute that jurisdiction.
Yes.
You've already applied. That's why the tribunal is sitting. And then the tribunal, which is, I haven't covered this, neither of us have covered this in the Skeleton argument. The tribunal has what is sometimes described as a quasi-inquisitional approach. The tribunal, whatever the application made by the patient, and when I say application here, I mean the patient says, either in person or through a lawyer to the tribunal, I want to be discharged, or whatever they do want. I want an absolute discharge, I want a conditional discharge. The tribunal is not a court that is adjudicating a claim. The tribunal is applying statutory criteria, which are mandatory, and no matter what the parties say, it is obliged to make certain decisions after it has decided those statutory criteria. I recall when we were looking at the criteria in section 72 and section 73, the word shall appears in both. So the tribunal is not acting on a claim form. It is making a decision as a result of the proceedings being brought to it by the originating application. That is how I would put it. Section 75.3, also on page 97, is potentially problematic for the appellant, because what it says is that sections 73 and 74 above shall not apply to an application under subsection 2 above, but on any such application the tribunal may A, vary any conditions to which the patient is subject, or B, direct that the restriction order shall cease to have effect. That means absolute discharge.
So section 73 and 74 do apply, do they, on
No.
an application under section 75(1)?
No. So, on an application...
Or a reference under section 75?
Oh, yes, a reference under section 75(1), they do apply.
Yes.
Well, one of them would apply. It's I haven't taken you to section 74.
No, you haven't.
The reason I haven't done that is because that is the section that governs the tribunal's jurisdiction in relation to prisoners or other detainees that have been transferred from prison to hospital. They are also restricted patients. It also imports the criteria in section 72(1)(b).
Sorry, I need to take this slowly.
Sorry.
74 refers to ex-prisoners transferred
Yeah. My lord,
to hospital.
The language can be, the status can be seen from the language in the title of section 74, because it applies to restricted patients subject to restriction directions.
Right.
And restriction directions are different from restriction orders.
Right.
Restriction directions apply to prisoners and other detainees who have been found to be suffering from mental illness and need treatment in hospital while they are in prison or detention, and are transferred during the currency of their detention, sentence, remand even, for that treatment.
Right.
But because they're prisoners, clearly the consequences of a finding that they no longer need to be in hospital must be different. So that's what section 74 does.
It struck me when we were looking at section 73 that the criteria which the tribunal has to apply seem to be identical for an application and a referral, because the introductory words say where an application is made, or the case where the case of such a patient is referred, and then it goes on to say what it has to do. But looking at section 75(3), it looks as though there may be a difference, because section 73 is disapplied in the case of a section 75(2) application. Have I misunderstood that?
No, my lord, you haven't. That's exactly right. This is why I say it's potentially problematic for the appellant, because you have to remember what a reference made under section 75(1) is doing, what causes it. What causes it is that the patient has been recalled, so was on a conditional discharge, goes back into detention in hospital. And so section 73 is what the tribunal applies. What section 75(3) does is govern the tribunal's adjudicatory jurisdiction and duties.
Can I ask what are the differences? And please tell me if this is relevant. What are the differences between the tribunal's powers under section 73 and the tribunal's powers under section 75(3)?
I have got quite lengthy submissions in relation to this, or detail.
So we're coming on to that.
We are coming to that, my lord,
Right.
yes, because it matters a lot. I wouldn't raise a potential problem for the appellant and then not at least try to address it.
Yes.
The reason why I ask that is because one of the points, as I understand it, taken against you is that in substance, the issues in such a situation will be considered by the tribunal under a reference, the same issues as will be considered under an application under 75(2).
Oh yeah, that's true.
If the tribunal's powers, however, are different in the two circumstances, then it may be that the processes are not identical.
No, my lord, that's right. It is a point taken against the appellant, but it's a bad point. And the reason for that is because the interpretation of whether the application survives a change in status can't be determined solely by whether it might or might not be of use. It either survives or it doesn't. The procedural and other consequences to the patient are not relevant. It survives by reference to the words of the Act and its policy and context, or it doesn't. That's the appellant's case.
So that's, as it were, I might say, the purist position. But if we go down to what it means in practice, that's what we're going to come to this.
We are going to come to that.
So my question, so you have it in mind, is are the tribunal's powers substantively different in the two circumstances, i.e. under 73 on the one hand, dealing with a reference, and under 75(3)
dealing with
in those circumstances?
the short answer is it depends on the patient's status at the time of the hearing.
The answer is yes, for that reason.
Yeah.
Thank you.
That, I think, covers section 75 for the time being. Until we get to the recall.
Test a scenario on this.
Sorry.
Not the facts of your client's case. But a restricted patient has been conditionally discharged. Applies under 75(2) for a tribunal hearing in which he seeks absolute discharge. A week before the hearing date, he is recalled because of some appalling episode where he's attacked somebody and maybe killed them or potentially caused grievous injury and so on. So he's recalled the same day. But you say the FTT must go ahead with the application for absolute discharge the following week.
No. I say that the jurisdiction survives because the tribunal retains jurisdiction as a result of the recall being an administrative detention.
Yes.
No matter what the patient does, the tribunal, no matter how grievous the reason for the recall, the tribunal has jurisdiction over his case as soon as he is returned to hospital by the recall. It is inevitable, and that is demonstrated by the duty of the Secretary of State to refer the case to the tribunal upon recall. So the answer is, were he to apply 1 week later, do something awful and be recalled, the tribunal would be, the tribunal's jurisdiction, even without that application made 1 week earlier, the tribunal's jurisdiction would be established by the reference.
Well, that's common ground.
Yeah.
But I thought you were saying that the fact of an application by the patient being on foot at the time, having been made but not heard at the time of recall, makes all the difference.
It's simple. All I'm saying on behalf of the appellant is that it survives the change in status. And we haven't got to this yet, but the point that follows from that is that there is a principle discernible in the authorities that where an application is made but status changes, the tribunal adjudicates the case by reference to the patient's status at the time of the adjudication, not at the time of the application.
Yeah.
Mr. Percy also points out a point that we will come to, which is there is also the effect of rapid changes of status. But I will go through that in shortly, if I may. 1st of March 2024, the appellant was recalled from conditional discharge by the Secretary of State before the hearing of the application that he made on the 13th of October 2023. The reason being that, in short, his mental health was observed to have deteriorated. The reasons for the delay to the hearing, to the application, to the hearing of the October 2023 tribunal application are not particularly relevant to this appeal, but there was a delay. The application, you'll recall, was made on the 13th of October. The recall occurred on the 13th of October 2023. The recall took place on the 1st of March 2024, and the application made in October had still not been adjudicated. The reason was at least partially because there were prolonged negotiations about exclusion zones. Prolonged negotiations about exclusion zones.
I'm sorry, Mr. Charlie, perhaps I'm becoming old and deaf as well as old and grumpy, but you keep dropping your voice in mid-sentence.
I'm so sorry.
So I still didn't. There were negotiations about
prolonged negotiations about exclusion zones applied as part of the conditional discharge.
Thank you.
Section 42, subsection 3, on page 31. Provides that the Secretary of State may, by warrant, recall a patient who has been conditionally discharged. So that's where the power comes from.
Section
42, subsection 3, on page 31 of the authorities bundle.
And what else may the Secretary of State do on recall? Can he or she add conditions or amend conditions?
No, because when the patient is recalled, the conditional discharge comes to an end. So recall means detention. But what he must do under section 75(1) is refer the case to the tribunal. So the purpose and effect of the issuing of a warrant under section 42(3) is that the patient is returned to hospital, at which point the detention aspect of the restriction order restarts. The patient is no longer at liberty and is locked up in a hospital for treatment. it's worth me just briefly observing at this stage that that is obviously an executive, administrative detention rather than a judicial detention.
Yes. Oh,
Yep.
of course it is.
Yeah. So shortly after the recall, 5 days later, the Secretary of State referred the case to the First-tier Tribunal. And this is where section 75, subsection 1, subparagraph A comes in. And that is at page 97. There is a duty on the Secretary of State to first, within 1 month of the day on which the patient returns or is returned to hospital, refer the case to the appropriate tribunal. And subparagraph B of subsection 1 imports section 70 by stating that it should apply to the patient as if the relevant hospital order had been made on that day. And that is the source, that is the genesis of the issue in this case. Because by importing section 70, the patient becomes again subject to the 6-month wait that applies after a judge has sentenced him. I don't know if that's clear.
Yes, it is. But, is that a bad thing?
It's relevant to the interpretation of the provisions because the Act deals differently with judicial as opposed to administrative decisions to detain. The short point is that where there is an administrative deprivation of liberty, detention in hospital, the Act invariably, apart from when it's for 2 or 3 days in some sections in Part 2, the Act almost invariably requires there to be a judicial decision by the tribunal.
But there will be, won't there? Because regardless of whether the individual happens to have made an application before he was recalled, there will be, within the 6 months, a judicial decision by virtue of the Secretary of State's referral. Isn't that how it works? So,
yes.
So there is going to be a prompt judicial decision. Meanwhile, the 6-month clock is starting to run again so far as any application by the patient is concerned.
Well, Jess, that's the respondent's point in a nutshell.
What is the substantive difference between how the tribunal is vested with the jurisdiction? Why does it matter in practice that the key thing is for a tribunal to have the jurisdiction to determine whether the patient restriction should be lifted and or he should cease to be detained? Why does it matter ultimately how the tribunal is vested with the jurisdiction?
Yes, there are potential advantages and inconveniences on either side of the question, essentially, of the jurisdiction surviving, which I shall come to. But there is also the potential problem of rapid conditional discharges, recalls, conditional discharges again, before a reference can even be made.
Yeah. So
Or is it made?
The scope for what might be called a tactical, not that's the wrong word, an immediate setting aside of the recall would have had the effect of preventing the tribunal from considering the merits.
Preventing the access of the patient to the tribunal, yes. It didn't happen in this case. The respondent rightly says that. And it is likely to be a rare occurrence. But the fact that it is a conceivable consequence of the respondent and Upper Tribunal Judge Jacobs' interpretation of these statutory provisions is, the appellant says, relevant to whether that interpretation is right.
But what are the circumstances in which it would actually occur? It's rather hard to think of any Secretary of State deliberately discharging somebody into the community, even conditionally, who is believed to be dangerous, simply to avoid an application to the tribunal,
No,
or a reference to the tribunal.
my lord, it doesn't need to be an exercise of bad faith. And it doesn't necessarily follow that the discharge would be of somebody who is dangerous. The point is that the Secretary of State has his own duties in relation to the detention of patients, including restricted patients. And it is part of the Secretary of State's duty that if it is brought to his attention that a patient no longer needs to be detained in hospital, and if there is no other way of doing it, he should exercise his power to bring an unnecessary detention to an end. It is not inconceivable that patients who are on conditional discharge suffer a deterioration in their mental health, which can be corrected by a short period of treatment in hospital before they are ready to be discharged again. Mental health conditions fluctuate. Often rapidly. And it is possible, and this was recognised by Upper Tribunal Judge Jacobs in the DD case and in another case that escapes me for a moment. Right. Thank you, MM in the Court of Appeal. There is a recognition that this is something that is, if not likely, if not common, nevertheless conceivable, and therefore is relevant to whether the respondent and the tribunal's interpretation of the statute is correct. I do have more detailed submissions in relation to this, which will probably be clearer because I've got them written down in front of me.
Okay.
But
the Section 75 is obviously at the heart of this.
yes, it is.
But Section 75, 1A and B do have to be taken together. If Section 75, 1A were not there, and the statute just said where a restricted patient has been conditionally discharged and subsequently recalled, he has to wait 6 months before he can apply to a tribunal. I would well understand your argument that this is outrageous. The executive can snatch somebody off the street and they're shut out from judicial determination, except possibly by judicial review or habeas corpus or something, for 6 months. But 75(1)A says if you are recalled, Secretary of State shall, within a month, refer your case to the tribunal. And it looks as though, well, in the present case, the reference was made within 4 days, and the tribunal had a hearing and reached a decision about 5 weeks later. And it may be that it is their practice, and you can tell me, or sales can tell me, to to give expedited consideration to recall cases for this very reason, that if under 75(1)(a) the Secretary of State makes a reference and the tribunal say, well, they're terribly busy, we'll give you a hearing in 6 months, that would be an outrage of a different kind. At the moment, I can't see why you are arguing for a lacuna on the basis of policy.
I don't know if I would characterise it, my lord, as arguing for a lacuna on the basis of policy, but rather on what the Act means when it says the patient may apply, and what Section 70 means when it says that the patient may not apply, by reference to the policy and the words. I will come to this shortly. We're almost at the end of the chronology, but the point is notwithstanding that there is, yes, the point is this: the answer to the question of whether the jurisdiction acquired by the tribunal during the conditional discharge survives the recall is not wholly answered by whether it is of any utility, even though I do say that in some cases it may be of utility. The interpretation of the sections in question is not answered solely by what might be practical in most cases.
Why does the Secretary of State's Section 75(1)(a) duty not survive a subsequent release? So somebody is conditionally discharged and is subsequently recalled to hospital. The Secretary of State has a duty to refer within 1 month. Well, suppose after a couple of weeks the patient is conditionally released again. Why doesn't the duty survive? It doesn't say and is still in hospital or anything of that nature.
Yeah, it should survive. And indeed,
So even in the bouncing in and out of hospital scenario, which is your lacuna, the referral duty still exists.
as long as the referral is made, as long as there's time for the referral to be made within that 1 month.
Well, what do you mean there's time? It's got to be made within a month.
It's got to be made within that month, but if the patient is, if there are delays to the making of the referral, of course that would be unlawful. But if the referral is only made at the end of that month, it is conceivable that the patient would be discharged before then, because patients can recover.
Well, so what? It doesn't say if he's discharged within the month.
No.
You don't have to refer.
If the reference isn't made, there's no reference to carry over.
There's an absolutely mandatory obligation to refer.
Yes.
So, and that's triggered by the recall.
Yes.
And the fact that he was subsequently discharged or released or whatever doesn't bring the reference to an end or the obligation to refer to it.
As long as a reference has been made.
Well, even if it hasn't been made, why does the obligation to refer lapse if the recall lapses? It doesn't say that. It's triggered by the recall.
Where a restricted patient has been conditionally discharged under section
And is subsequently recalled.
subsequently recalled to hospital, the Secretary of State shall, within 1 month of the day on which the patient returns or is returned to hospital, refer his case to the appropriate tribunal. Yeah, on one reading, that's absolutely right, my lord.
Well, it seems to me, as an amateur in these matters, that it is clearly unqualified. Tribunal might say, well, we're not minded to organise a hearing because things seem to be going very well, or at least we're not going to prioritise a hearing. But that's a different question. The obligation to refer is not. It doesn't say where a restricted patient has been conditionally discharged, is subsequently recalled and is still in hospital
and
or
stays there.
has not been discharged again.
And if that is right, I appreciate this is a new point, but if it is right, then the opportunity to apply under section 75(2) adds nothing on the assumption that the Secretary of State complies with his duty.
Sorry, the opportunity to apply under section 75(2) or the previously made application under section 75(2).
Well, either, I suppose, but I was thinking of the previously made application.
Yeah.
Assuming the court's powers are the same on a reference and an application.
Yes.
The tribunal's, they're the same.
Yeah. If I can just have a brief word with Mr. Percy about
Yes, of course.
something. The reason I'm taking time to speak to Mr. Percy is because, as far as I can see, this isn't a construction that has been thought of by either party, but it's a good one.
Well, I'd be suspicious of instructions which haven't been thought of by either party, because Ms. Ailes may have a reason for explaining to us later that it's wrong.
Yeah, Mr. Percy just told me that he'd want to think about it, but at first glance it looks good. I would say the same thing, but it may be that it may be that we need to give that some thought as a potential answer to the case. It may be. We certainly need to give it some thought. I don't know. I don't want to speak for Ms. Ailes, but from what I can read from the statement arguments file.
In this case of all cases, it's not particularly adversarial. Strictly speaking, for your client, on the facts, this is academic anyway, but the jurisdiction point is quite significant. That's why senior presidency now gave leave, and we're engaged in a search after truth rather than find winners and losers. So
Yes.
if it turns out that we're diverting you all down a cul-de-sac, we won't object to being told.
Yeah. I'm being asked, and I agree with the request, whether we can have a short break so that we can consider it and discuss it, because if it is the answer to the case, that might be useful. Subject to your lordship's
Yeah,
views.
do that. All right, we'll come back at 12 noon.
Rise of April.
I don't know, is the recording still on? So we should go outside.
Yeah.
Actually, that's a good point. We would need to check to be absolutely sure ourselves that we're not opening into the floodgates by accepting that. Because what if that requires the judge's construction of Section 75(1) duty to observe also applies to other mandatory duties that refer in 71, 7 and 8. Well, that's not perhaps a question. So, I'm so sorry, yes. Oh, I know. I saw that.
Court rise is able.
My lords, thank you so much for the time. The search for truth has progressed. On the time that we've had, I have had an opportunity to discuss with the expert solicitors who sit behind me, who understand the practicalities of all of this, with Mr. Percy, who has a deep knowledge of the Act, and with Ms. Ailes, who also has a deep knowledge of this Act. Those behind me referred me to section 71(2), which is interesting. First, because section 71 as a whole governs references by the Secretary of State concerning restricted patients.
Section 71.
Sorry, section 70.
Subsection.
Yes.
Section 71.
71 on
71.
page 86.
Yep.
So, subsection 1 says that the Secretary of State may at any time refer the case of a restricted patient to the appropriate tribunal. So that's a discretion. But we're talking about a duty, and that's in subsection 2. The interesting thing is the language in subsection 2 and the specificity of it when it expressly refers to the duty arising in the case of any restricted patient detained in a hospital. The thinking on the appellant's side is that tends to support the court's construction of section 75(1), because section 75(1) does not make any express reference to whether the patient is detained or continues to be detained or not when the Secretary of State's duty to refer under section 75(1) is exercised. So far, what we've found supports the soundness of that reading. And if that's the case, it solves the Article 5(4) problem. Because even if a patient is discharged before a reference is made, the duty to refer persists. It's tying the duty to refer to an event, essentially, as I see it.
To a past event, yes.
Yeah. The thing is, and I don't wish to speak for Ms. Ailes, but it's not something, as I understand it, as any of us understand it, that the tribunal or the Secretary of State currently does. It would, if that is the correct reading of the Act, it would mean that there would need to be a new policy and practice in my learned friends' clients' management of mental health cases.
Well, are there cases in which a referral has, a hypothetical example you've postulated, have there been cases where a referral has been followed by a swift discharge? Has that ever happened before the referral has been considered?
I don't
Reference, not referral.
know. I don't know the answer to that. There are in the 40 odd years that the Act has been in force, there may have been. There have been tens of thousands of restricted patients, and as I said earlier, it's conceivable that it could happen, that a patient just needed a short time of treatment in hospital before their mental state stabilised and they were fit for discharge.
Yes, but as Judge Jacobs points out in his judgment in this case, once a reference has been made, i.e. lodged, it can't, there's an express rule prohibiting the Secretary of State from withdrawing it. So it's then, the tribunal is then seized of it. So in the present case, the recall is on the 1st of March, and the reference, you said, was made on the 5th of March.
Yeah.
So if, as it were, the authorities had perhaps improbably changed their mind in the intervening 3 days and discharged the patient, then maybe well, then one would be considering whether the duty to refer remained. But once the reference is made on the 5th of March, even if the patient had been discharged by the hospital with the agreement of the Secretary of State, this is a restricted patient, following week, it would still be on the tribunal's digital desk, and it would be for the tribunal to decide how to proceed. That's right, isn't it?
Well, if the reference has been made and creates a valid jurisdiction, the tribunal has a duty to exercise that jurisdiction. There are case management powers that are separate. I'm just wondering about the implications, if there are any, of the bar on a patient making an application in the first 12 months of a conditional discharge. I'm not sure there are. But because what that would mean is that there could be, if jurisdiction, if the appellant's construction, or if the appellant's interpretation of whether an application made while the patient is subject to a conditional discharge survives recall, if the appellant is wrong on that, and wrong because section 75(1) requires a reference to be made even if the patient is rapidly discharged, then there would be no possibility of a concurrent application and reference in the period following the discharge, because any application made before recall would not survive, and the patient isn't empowered to make any application after the next conditional discharge for 12 months. So the reference would be the only jurisdiction that, on this reading of the Act, the tribunal could possibly acquire.
Could we go, if it's convenient, back to the question I raised a little earlier, which is comparing and contrasting the tribunal's powers in the two situations?
Yes.
Now, what you told us was that under section 73, which would apply, wouldn't it, on a reference?
Yes.
The tribunal, it says the powers of the tribunal are under 72, 1b, 1, 2, and 2a, little 2a.
Yes.
And the tribunal is obliged, shall direct the discharge, unless, if not satisfied, of all three of those provisions.
Correct.
So that's a mandatory obligation.
Well,
No.
yeah.
Yes.
Shall
If it's
discharge.
not satisfied that 1 or 2 or 3.
If it's not satisfied that any one or more
Yes.
are met.
Whereas under section 75(3), the tribunal has a discretion.
Yeah, it's not possible to answer this, my lord, without referring to DD, which is the case at 14, tab 14, page 327. The reason I say that is because DD was the exact mirror image of this case. DD applied while detained, and then so he was a restricted patient who was detained in hospital. He applied under section 70, as he was entitled to do. He was then made subject to a conditional discharge before the hearing of the application. And the question for Upper Tribunal Judge Jacobs in that case was whether the jurisdiction created by the application under section 70 when he was detained survived over the transition in status to conditional discharge. The answer was it did. The reasoning starts at page 322. Paragraph 19, I would suggest, is key. And this goes directly to your question, my lord, because I'll read out 19.
I don't think it's page 322.
Sorry.
I think it's tab 14, DD.
Yeah, it is.
This is DD in the Upper Tribunal,
Yes.
in which you appear with Mr. Simblett.
Yeah. Paragraph 19 is 334.
Yes.
Yep.
334.
So, when DD applied, Upper Tribunal Judge Jacobs said, when DD applied to the First-tier Tribunal, bless you, its jurisdiction was conferred by sections 73.1 and 73.2. So that's the detained powers. The powers of the tribunal over a restricted patient who is detained. The issues were set out in those subsections, and the relief available depended on which conditions were satisfied. Once DD was conditionally discharged, the relief sought narrowed the conditions to be imposed. Although DD's status had changed by reason of the conditional discharge, there was still an issue under section 73 over which the tribunal retained jurisdiction. It was therefore wrong to decide that it no longer had jurisdiction. Now, there is, I think I've already mentioned this, but there is one additional factor to take into account when considering when section 73, when the tribunal has jurisdiction under section 73, I think is the question, and that is the first sentence of section 73. Subsection 1. This is page 92. And my lord will see that what it says about the status that provides the tribunal with its adjudicative jurisdiction to make the decision about absolute or conditional and the 72.1 criteria is only that an application is made by, quote, a restricted patient who is subject to a restriction order, end quote. The problem is that that description applies to both conditionally discharged and detained patients.
Yes.
So on that reading of that language, section 73 can be applied by the tribunal to the case of a patient who is conditionally discharged, section 75(3) on page 97 says that it shall not apply to an application under subsection 2, which is an application made by a patient who is conditionally discharged. The point that I was going to make is that there is a tension between the language in those two subsections, which should be resolved in favour of the principle that the tribunal applies the test that is relevant to the status of the patient, not at the time he made the application, but at the time of the hearing.
But is the answer to the question, are the powers effectively the same whether the tribunal is dealing with a recall case, sorry, a case of a reference under 75(1)(a) following recall, or an application by the patient under 75(2)? Do they have the same powers?
Yeah. The question for the tribunal under 75(3) is whether a restricted patient should be subject to conditional discharge or absolute discharge.
Yes.
The question for the tribunal under section 73 is whether a restricted patient should be subject to conditional discharge or absolute discharge, or neither. The core issue.
But doesn't that follow anyway from the use of the language may? If the patient is currently detained in hospital, the tribunal can conditionally discharge, absolutely discharge, or refuse to do either and say you stay where you are. But isn't that the menu of options available in either case?
In no other case.
In either.
In either case. The section 75(3) tribunal can direct the restriction order ceases to have effect. That's the same as absolute discharge.
Sorry, Mr. Petzani, you're
I'm so sorry.
Again.
I'm so sorry. The section 75 tribunal can decide, setting aside the variation of conditions part of it,
Yes.
can decide that the patient should remain conditionally discharged. In other words, the patient could ask the tribunal for an absolute discharge. The tribunal says no.
Yes.
Or that the patient should be absolutely discharged. Or, yeah, there is no neither, because the status of the patient is either one or the other at the time that the tribunal is hearing the application under 75(3), because the patient isn't detained. And if the patient is detained, then the question that the tribunal should be asking is the question in section 73. Does that, I'm not sure that's clear, but where the tribunal is considering a case under section 75(3), unless the patient has been recalled and jurisdiction has transferred over, then the patient will be conditionally discharged. So that's status 1.
Yes.
The tribunal's decision is whether he should remain conditionally discharged or be absolutely discharged. So that's potential status 2.
Or the conditions.
Or the condition
Varied.
varied. Yeah. But there is no neither conditionally discharged nor absolutely discharged, as there is in section 73, because there is no detention.
Yeah.
So there is no neither. It's one or the other.
Well, there's may. The word is may.
Yeah.
Court decide to do neither if it has such a discretion.
Oh yeah, it can decide.
Sorry.
Well, I'm sorry, my lord. No, I don't think it can, because if it refuses to direct absolute discharge, then inevitably the patient remains conditionally discharged.
If the patient has been conditionally discharged but not recalled at the time when he makes his 75-2 application, then on your case, that the application survives a change in status, it's still there and has to be determined. But if we then look at section 73, section 75.3, to see what can be done to a patient who, by the time of the hearing of the application, has been recalled, then paragraph A simply can't apply, because at the time of the hearing there are no conditions subject to which the patient is subject, because he's been recalled and conditional discharge is no longer in force.
Yeah.
So the only thing that the tribunal can do, as section 73 and 74 don't apply, is direct, in effect, the absolute discharge under B, which, although theoretically possible, is unlikely in the case of a patient who has been recalled.
Yeah.
I suppose you might have a rather far-fetched case where there are 2 patients called John Smith and they've recalled the wrong one.
Yeah.
Something like that. But leaving aside that rather unlikely example,
Yeah.
the patient will have done something which has caused the Secretary of State, assuming good faith and all the rest of it, to think that it's appropriate to recall, and it's very unlikely that absolute discharge is going to be appropriate.
Yeah. But the path that I would have taken to get to that proposition, that shouldn't detract from the appellant's reading, is that where a patient's, the principle discernible from the authorities and the context of the Act, is that where a patient's status changes, for example, from conditionally discharged to recalled and detained between application and hearing, then the tribunal considers the case by reference to the patient's status at the time of the hearing rather than at the time the application was made.
Yeah.
And in the situation that you postulate, my lord, the tribunal would not be applying subsection 3 of section 75, it would be applying section 73. And it could do that on the express language of the Act, because all that is required in section 3 for the tribunal to exercise its jurisdiction is that application has been made by a restricted patient subject to a restricted.
No, but it's fundamental to your case that it is an application under section 75.2,
Yeah.
and that it survives as an application under section 75.2, and then subsection 3 comes in to rule out section 73.
No, my lord, it survives as an application that was made originally under section 75.2. The tribunal acquired the constitutive jurisdiction was acquired when the patient was conditionally discharged. But again, by reference to the principle that the patient's status at the time of the hearing of the application determines how the tribunal adjudicates it. If the patient has been recalled, then it makes sense for the tribunal to consider the case under section 73, which is relevant to the patient's status at the time of the hearing, rather than by reference to section 75(3), which was relevant at the time the patient made the application and created the jurisdiction.
So the
but is no
recall post-application transforms the section 75(2) application into some other kind of application,
No.
i.e. under section 73.
That's not needed under the statutory language, because a patient that makes an application under section 75(2), when he's conditionally discharged, is a restricted patient subject to a restriction order. And if my Lord looks at section 73 again, page 92, subsection 1, the tribunal's duties under section 73 on that express language apply equally to an application made by a patient who was conditionally discharged as an application made by a patient who is detained. The acquisition of jurisdiction requires only that the application or reference is made by or in relation to a restricted patient who is subject to a restriction order. That's both detained and conditionally discharged. But it makes sense for the tribunal, where the scenario that we have discussed and that took place in this case occurs, it makes sense for the tribunal to apply that jurisdiction because the patient is detained, and 75(3) makes no sense where the patient has been recalled and detained, but section 73 does, and both are sufficient. Sorry, the language of both is sufficient to allow the tribunal to apply one or the other when it adjudicates the application. Hence the principle, which also applies to many of the cases decided about Part 2 patients. Hence the principle that that the tribunal acquires jurisdiction under a particular provision, but when it adjudicates the jurisdiction that it has acquired, it should do so and can rationally only do so in relation to the patient's status at the time of the adjudication.
Well, I think that's common ground.
Yeah.
I'm sorry, perhaps I'm being slow, but I still don't see why this matters. Suppose what in fact happened is that in September 2024, in April 2024, the FTT decided it had no jurisdiction on your client's application. That decision was appealed to the Upper Tribunal, and Judge Jacobs agreed that the FTT had no jurisdiction on your application.
Yeah.
But meanwhile, the FTT was seized of the reference, and on the 4th of December 2024, according to your skeleton argument, the FTT conditionally discharged your client.
Yep.
Presumably it could, at least in theory, have absolutely discharged your client, but it didn't. We haven't got the judgment.
No, but that's right.
Suppose that Judge Chamberlain in the FTT and Judge Jacobs in the Upper Tribunal were wrong, and there was jurisdiction. Surely the tribunal, on receipt of the reference, would, if you're right, have said, well, there's still the patient's Section 75(2) application kicking around from last year, October 2023. So we will list it to be heard together with the reference hearing. It won't make any difference to our powers. We will still have the same suite of options.
Yep.
So why does this matter? Why would your client have been better off if the FTT and Upper Tribunal had decided that they did have jurisdiction?
Yeah. Because the issue is statutory interpretation, I suggest that it's legitimate and perhaps even necessary to look not just at what happened to my client, but what could happen in a range of cases, so that one can understand the context and purpose of the legislation. And to that end,
well, can I
Yeah.
just pick you up on that? And say, what you're saying is there might be a case in which the department, either through malevolence or perhaps more plausibly through incompetence, failed to make a reference.
no, I'm sorry, my lord. I'm sorry to interrupt,
Yeah.
but I'm trying to envisage situations where there is a coexisting reference and surviving application, and what might happen. What I've come up with is, for example, if the mandatory reference was not heard before the expiry of the first 6 months of the recall, the patient could make an application. But if it was heard towards the end of the first 6 months, for whatever reason, for administrative reasons, the availability of judiciary, the preparation of evidence, then a pre-existing application that could be heard more swiftly at the beginning of those 6 months would be consistent with the Act's policy of swift judicial consideration of an administrative detention. But that is potentially an outlier as far as examples are concerned. The result, I say, of the survival of jurisdiction created by the October 2023 application would, at worst, have been minor procedural inconvenience, easily solved by the Tribunal's case management powers to consolidate two sets of proceedings, as your Lordship has already noted. But at best, if there were delays in the making of the references, of the reference, or other delays, the result would be a swift hearing by the Tribunal after recall, which accords precisely with the Act's purpose. Thus, there is the potential for the survival of the jurisdiction to be meaningless, making no difference at all, a minor inconvenience, or of great utility, depending on what happens in the individual case.
And can you give an example of where it would be of great utility?
There is an example. There's an authority that isn't in any of the arguments or in the bundle.
Surely not. You have 370 pages of authorities.
No, it's an old. Can I just ask my instructions for a copy of Jones, because that will allow me to do it accurately. I think it's K in the UK. It's a Strasbourg case. Can you see if you can find it? I have in my mind, I haven't looked at it for a while, that it became a Strasbourg case because the delay was inordinate.
We've got the reference, please.
Yeah, I haven't found it yet, my lord. I'll tell you as soon as I have. Oh, here we go. Let me just check it's the right case. Maybe it's not. I'm sorry, I may have mistaken the name of the case. I just want to make absolutely sure.
Well, leave it for the moment,
Yeah.
Mr. Pezzani. We must get on. Speaking for myself, I doubt whether a Strasbourg decision is going to help us very much on the interpretation of these statutes.
The only thing it does is, the only reason I mention it is because it provides an example of a very long delay in the hearing of a reference.
Yes.
I suppose the point is, swiftly made reference doesn't necessarily equate to swiftly heard reference.
No, but that seems to me that the 1 month period specified, mandatory reference within 1 month, is a signal to the tribunal, which at least they seem to have taken in this case, that they must deal with such applications promptly. They're obviously, the civil liberties and human rights and implications are obviously much greater. Somebody who's been recalled to hospital than somebody who is already discharged and wants an absolute discharge.
Oh, yes.
A tribunal can, if it doesn't organise its lists properly and its priorities and so on, inflict delay on parties, but I don't see at the moment why the existence or otherwise of a 2023 application, which is a bit fortuitous, makes a difference to the urgency with which the case would be heard, and it seems to be common ground that there's no difference in powers.
No, my lord, there is a small sort of caveat to that analysis, which is that even if the tribunal doesn't inflict delay on the hearing of the case promptly, it is possible for the patient or the hospital witnesses to inflict delay on a swift hearing. The patient can do it by saying, I want expert evidence to put against the expert evidence that will be, by the rules, put before the tribunal to say that I am lawfully detained. And that can take time. The hospital can do it, inflict delay, I mean, by saying, we haven't had this patient here before. We agreed to admit him because it was an urgent recall, but we can't possibly give you a sensible opinion on the issues in the case, whether he needs detention, why, what sort of treatment is appropriate for him, until we have had time to get to know the patient. There are therefore potential ways that the tribunal hearing could be delayed, no matter the tribunal's policy of hearing the case as soon as possible. Sometimes as soon as possible doesn't equate to soon. Now, I may well be accused, and probably justifiably, of improper speculation here. But let us say that one or a number of those things happened, so that a reference made within days of the recall ends up with adjournments, postponements, requests for evidence not being heard 4 months later or 5 months later. Suppose, secondly, that the patient, like this appellant, had applied just before recall when he was conditionally discharged. And suppose that his intention in making that application was to argue that he didn't suffer from a mental disorder, and that he had the evidence and arguments ready to go, marshalled, at the time that he was recalled. There is no objection and every advantage in, and I absolutely accept this is essentially me just making stuff up, but still, there is no objection and every advantage in that situation to the patient having the hearing that he was hoping to have before he was recalled, by reference to the evidence and arguments that he has already assembled for the purposes of the application he made when he was conditionally discharged. And then, because the reference is taking longer, because there's other evidence needed, or the responsible clinician wants time to get to know the patient, or there are delays in the system or whatever, the reference to be heard thereafter, that is an example.
But how could that be right? I thought you've accepted it. Seems to me obvious common sense that the tribunal has to make a decision on whether the patient is well, not so well, fit to be discharged, and so on, at the time of the hearing.
Yeah.
On the review hearing, you would be able, as I understand it, to adduce evidence if you'd collected it, saying that in the autumn of 2023 he seemed to be doing very well, and so on. The tribunal might say, well, that was then, this is now, we have to take account of what happened Monday, a fortnight ago. I still don't see what the advantage to you.
Sorry, the point I was trying to make is that if there were delays to the hearing of the reference, but the evidence in relation to the discrete point of mental disorder, yes or no, had already been prepared, then the delays to the reference would be less intrusive on the patient's rights to a judicial determination, because there was already an application ready to go, and if jurisdiction survived, it could be heard early in the period of recall, no matter that the mandatory reference was, for various good and proper reasons, delayed into the 4th, 5th or 6th month.
The tribunal dealing with that application, which you say was ready to go, will look at the evidence of the expert saying that he no longer has any mental disorder, and will say, hold on, since you produced that report, he has done this or that, and been recalled to hospital. What's all that about? How does that affect your opinion?
Yeah.
And so you're not ready to go.
No, but my lord, you are ready to go, because the expert could then answer that, and the point would be decided. The expert, I mean, it's so speculatory that you know, either of us could say anything about what the expert might say, but the point is there would be an adjudication of that case. And even if it was an adjudication that, yes, there is a mental disorder, the expert himself says so now, or the expert's evidence that there isn't, is obviously not persuasive given what happened to cause the recall. There is then an adjudication on the lawfulness of the patient's administrative detention, and that is an advantage.
Okay. Right. What further ground do we need to cover?
My Lord, I am, albeit happily, because it's such an interesting point, but I have been diverted by the court's new interpretation of section 75(1), and so haven't even started on my review of the authorities, haven't even finished the chronology, and haven't started making the 7 points that I wanted to make, although many of them have been made already just in discussion. The other thing that I'm conscious of, though, is my learned friend Miss Ailes, when we went outside just about an hour ago, was concerned about the position that she is able to take on the court's interpretation of section 75(1), given the potential implications to the policy of her client's department. So it may be useful.
If you would like to hand over to her to answer that question, we would be assisted.
Yes, well, my lords, on the appeal as it's pleaded, my lords have my submissions in writing. I'll obviously respond when I have the opportunity to do so, but I don't anticipate that the submissions that I will make will introduce any dramatic new legal points over and above those in my skeleton arguments. On the new point in relation to the interpretation of section 75(1), the Secretary of State had until now been approaching the case on the basis that that point was essentially academic and did not arise in the appeal. I take the force of my Lord's observations that we're here to consider questions of jurisdiction and search after truth. I have sought some instructions. I hope over the short adjournment to be able to refine them. So I hope to have a concluded position on that point after lunch. I'm not able to assist now on what it will be. And of course it may be that my position remains that it's academic and that the court shouldn't decide it.
Thank you. And before you dive into any authorities, particularly authorities below the level of this court, just tell us what the other points you're going to seek to make.
Yeah, thank you. First, I was going to make points in relation to purpose and context. A lot of it's already been said, but by reference to the ADA authority and the GM authority, I was going to explain why the tribunal can retain jurisdiction over an application where the applicant's patient's status under the Act changes between application and determination. The reference for that is paragraphs 10 and 11 of ADA at page 245 of the authority bundle. And then I was going to refer to the GM case 255, again a judgment of Upper Tribunal Judge Jacobs, explaining why that isn't always the case.
Right.
So the contrast between
that's point what
admin and
I'd
judicial.
quite like you, before we rise for lunch, to tell us what points
okay.
still have to cover, because we've only got today for this case.
Yeah.
Right.
Secondly, words. What about the statutory words? The the point is, in brief, that the statutory words, the language in section 75(1)(b), read with section 70(a), does not expressly invalidate the jurisdiction validly created by the appellant's application. All it does, expressly, is prevent the making of a new application in those first 6 months. So the respondent's case is seeking to imply a meaning that isn't there in the express words. And I was going to say that one might expect greater clarity where the issue is liberty and access to justice for somebody deprived of their liberty. One might expect clear words if the respondent's jurisdiction is right.
Point 3.
The significance of the reference and the potential practical benefits, which we have already
I think we've
been
covered
through.
that, haven't we?
Point 4, the flaws in the respondent's explanation for Upper Tribunal Judge Jacobs' decision. I was going to start that by remarking that paragraph 26 of Upper Tribunal Judge Jacobs' decision doesn't actually say why he took the point that the words only say one thing, but I better quote it properly. Sorry. Yeah. Core bundle 87.
Don't argue the point now, just tell you. You said you had 7 points, and
Right. I was, sorry. This is 4. Essentially, this is saying that the statutory precondition for no longer being met point is wrong, because the statutory precondition referred to by the respondent is a statutory precondition expressly to making the application and to nothing else, not to its adjudication or determination.
yes,
Secondly, that the distinction drawn by the respondent between section 66(1) powers and section 75 is false. There are more similarities than differences between section 66(1) and section 75(1)(b), so that there is no reason in principle when the case is about section 66(1) should not be good authority for the survival of jurisdiction in relation to section 75(1) and 2.
right. That was
That was point 4.
yeah.
Point 5, the respondent's point about the meaningless of the powers that a tribunal has after under an application made while the patient was conditionally discharged, but then is recalled. This we have basically already been through quite in
Yes.
detail. The only additional point to make there is that exactly the same meaninglessness can be seen in ADA, page 243, because guardianship and detention are not the same thing, and it is meaningless to apply the guardianship criteria for discharge to a patient who's detained and vice versa.
Right, that's point 5. Point
Yeah.
6.
Point 6 was just a reference to section 77(1), which is precise in its language. and refers only to applications rather than to their adjudication. And last, point 7, which was going to be the longest point, but probably is now the shortest or completely odious point, was about the relevance or otherwise of Rayner, this court's decision in Rayner. But the point essentially is, how can I reduce it to a tweet?
Miss Ailes says it's binding and you say it's distinguishable.
No, I say that it is relevant to the way that Section 75 and Section 70 should be interpreted, because an interpretation that requires a patient to go outside the Act for judicial supervision of his detention is less persuasive and likely to be right than an interpretation that does not require that, but instead solves the problem internally to the Act. And I was going to make some points which surprisingly were not made in Rayner about the reality for detained patients of trying to get a case to the High Court compared to the reality for detained patients of getting a case to the tribunal. And I was going to point out a number of real-world obstacles
Yes.
to that.
Right. Now, we'll break off now till 2 o'clock. Would you and Mr. Percy decide, first of all, whether you're going to make all these points or you're going to hand over any of them to him? Speaking for myself, I think you should regard 2:30 as the absolute limit of the time you take. I don't think Miss Ailes will require half a day, or at least I hope not. But even then, we're pushing at the boundaries. So we'll try to talk less this afternoon, and I include myself in that. But we have been trying to get our heads around these sections and see what the point of the case is. 2 o'clock.
Successfully.
Court rise if able.